In talking about the Establishment Clause, the Supreme Court ruled in 1947 that the Establishment Clause, which limits what Congress can do, also limits what states can do. It did so by invoking the 14th Amendment, which says no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. But the Establishment Clause did not create a right in any individual, but rather protected the state's rights. So, and that's come into play now in Oklahoma and in Texas with St. Isidore. What is your position on that? Because it seems to me that they're saying that Congress shall make no rule. It doesn't say anything about states. In fact, it leaves it to the states, does it not?
So everyone understood that the Bill of Rights originally was only a restriction on the national government. There's really no question about that. The only question comes when we have the 14th Amendment, where the relevant section begins, the relevant article, no state shall, ... abridge the privileges or immunities abridge due process. And it's through that due process clause that the U.S. Supreme Court, one by one, applied the Bill of Rights to the states. Now, there are scholars and jurists who argue that this entire doctrine is flawed, and we should just be done with it altogether, and the state of Virginia would no longer be restricted by the freedom of speech, freedom of press, free exercise of religion. There are scholars who make that argument. I'm a little bit sympathetic to it, but I'm enough of a Burkean conservative to say that we have lived under this doctrine from so long that ship has sailed, that we're stuck with it. Now, with the Establishment Clause, there is an additional argument, which is that it's only a matter of federalism. Akhil Amar has made this argument, Clarence Thomas has made this argument, and so it is by definition unincorporable. So maybe all these other provisions of the Bill of Rights remain applied to the states, but the Establishment Clause should not be applied to the states. Justice Thomas seems to be the only justice that's open to that argument, and so I think we're stuck with the Establishment Clause applying to the states for the foreseeable future. And so I think what we need to insist upon is that justices get that the Establishment Clause right. And so it was applied to almost any case you can think of, including St. Isidore. I think there's no way, shape, or form that the Establishment Clause should be read to prohibit Oklahoma from creating a religious charter school on the same terms that it's created other charter schools. And in fact, it's a violation of the Free Exercise Clause to say we're going to create all sorts of charter schools, but not a religious charter school. So I think there's a way around the incorporation doctrine, not that we're trying to get around anything, but just even with the incorporation doctrine, the Establishment Clause shouldn't prohibit a number of these things that you probably have in mind.
Can you not make the argument that they're actually discriminating against the religious school?
Absolutely, and there's this wonderful trinity of cases where the U.S. Supreme Court has said time and time again, look, states, you cannot discriminate on the basis of religion. Look, Maine, you cannot say that you'll pay to send kids to high schools of all sorts except for religious high schools. You can't do that, and that's why really the Oklahoma charter school should have been permitted to exist. And I think when we get the next case and Amy Coney Barrett doesn't have to recuse herself, we'll have at least a 5-4 vote, maybe a 6-3 vote upholding religious charter schools. Clearly constitutional, no question.
Thank you.